Hello and welcome. It's a pleasure to be here with you for lunch and a fascinating discussion. Thank you for all of you. Thank all of you for coming, and thank you as well to our viewers joining us via the live stream. My name is Nate Kazmarek, Vice President and Director of the Practice Groups for the Federalist Society. The theme for today's fireside chat is an unconventional view of intellectual property and antitrust policy, which is taken directly from Professor Jonathan Barnett's excellent paper with the same name and published in CPI last year. We are looking forward to exploring Professor Barnett's work and viewpoint that IP rights are not just exclusionary tools, but also enabling in many important ways. We're delighted that the co-chairman of our IP practice group, Executive Committee, Brian Pandya, is here to help us guide this conversation. Brian is a partner at Duane Morris LLP, where he represents technology, manufacturing, and healthcare companies. Before joining Duane Morris, Brian served as at the U.S. Department of Justice as a Deputy Associate Attorney General from 2019 to 2021. He clerked for Judge Leonard Davis on the United States District Court for the Eastern District of Texas. And full bios for both Brian and Professor Barnett are available on our website, fedsoc.org. Before I hand things off to Brian, a reminder to our audience that we have set aside ample time for your questions at the end of the program. So please think about what you'd like to ask and ensure that whatever it is, it ends in a question mark. With that, Brian, the floor is yours.
Great. Well, thank you, Nate, and thanks, everyone, for coming out to today's lunch. You know, I was thinking 20 years ago when I moved here from East Texas that the idea that you would fill a room at the Mayflower Hotel to talk about IP and antitrust policy was a preposterous idea. But I don't think there's any area of law that has seen an increase in interest than IP and antitrust law in the last 5 to 10 years. But I think that interest is genuine because it's vital to national security, to the economic future. It's vital to innovation. So with that, we're happy to have Professor Barnett here to talk about his paper, and he may also talk a bit about his book, which I also highly recommend taking a look at when you get a chance. So, Professor, your paper is called An Unconventional View of Intellectual Property and Antitrust Policy. Now, you begin your paper with this statement. It is commonly assumed that intellectual property rights and antitrust law stand in inherent tension. Is that the conventional view of IP and antitrust policy?
I think, unfortunately, it is still the conventional view. If we look at the academic literature that informs the policy debate, if we look at policy output from think tanks, if we look at discussions in Congress, if we look at many opinions issued by the judiciary, there seems to be an assumption that an IP right is properly described as a monopoly, which is factually incorrect in the vast majority of circumstances, and therefore it stands in logical tension with the purpose and objective of the competition laws, which is, of course, to promote competitive markets.
So, no, I mean, for as long as I've done this, that view has always been accepted as a ground truth. Can you explain how the conventional view of IP and antitrust came to be? Like, what is the basis for that? Why is that just an accepted notion in a lot of the discourse today? I know you're changing it, but why is that accepted?
Sure. It definitely has a long pedigree. If we look at the federal case law, you'll see an IP right described as a monopoly over and over. I think in turn it reflects a truncated, incomplete understanding of IP rights. It understands IP rights as a tool to exclude competitors from the market. Now, it certainly has that role, and we see that salient in litigations. But the vast majority of the time, anyone who's worked in the business world, I think, would be sympathetic to this view. IP rights are enabling transactions that wouldn't otherwise be possible. They're not exclusionary in that case. They're inclusionary. Let me give you an example. Let's say I'm a biotech startup. I was founded by a scientist. I got a license from Stanford University. I have a specific example of mine, which I will reveal in a second. I then need financing in order to finance that startup. I need to go to VC firms who have the capital. I then need the production and distribution expertise and testing to go through the FDA process. I need to complete all of that in order to monetize that innovation. Now, what do IP rights have to do with that? Because at every single step when I'm interfacing with someone who's supplying something that I need to convert that innovation into a product, I'm revealing information. I'm putting my IP at risk. I need that property right to protect my IP. I can put it on the table, and now we get a transaction enabling effect, and it's far more powerful than that. We get a market multiplier effect. I just described for you in a couple sentences the structure of the biotech industry roughly since the late 70s, early 80s.
Yeah, so that's biotech, but I mean, does that apply elsewhere? I mean, I know I think Elon Musk said recently, and I think he said this before too, that the patents exist for technology that is hard to develop and easy to copy. But for areas where there's different economic structures, does that notion hold true? I mean, I think well, give semiconductors as an example.
Sure, semiconductors is a great example where IP rights have been essential to enabling a specific type of business model that supports innovation, one, supports entrepreneurship, two, makes the market more competitive. Let me give you another example, okay? Throughout the post-war decades, referring to World War II, the semiconductor industry was mostly comprised of companies that look like Intel today. It's vertically integrated. From A to Z, everything is happening inside the corporation. Patenting was not a big deal in the industry at that time, and that makes sense because you don't have that knowledge leakage problem that I just described in biotech. All the information is in-house, it's embedded in the final product, it's monetized through the product. If you start looking at data from the USPTO at semiconductor classes in the late 90s, early 2000s, you see a sharp uptick in patenting. And there were predictions at the time that this would hurt the industry and innovation would be suppressed beneath a thicket of litigation and licensing. In fact, exactly the opposite happened. Patents enabled what we're very familiar with today and is now the dominant business model in the semiconductor industry, known as the fabless model, meaning you don't need a fab, you don't need a production facility. Again, what in the world do IP rights have to do with this? Because when companies like Marvel, when companies like Qualcomm start entering the industry as fabless firms, there's no production facility, they need to interface with foundries like TSMC. The fabless firm, the foundry firm, they're dependent on IP, not just patents. Copyright, trade secret, contract, all of that comes together to create a property envelope. It allows information to be exchanged. Again, transactions were enabled that wouldn't otherwise be possible. That's entrepreneurship. That's innovation. You just got a mega policy win on competition. Why? Because you just killed the moat around the vertically integrated firms like Intel. Why is that? Because you just reduced the capital requirements to enter this market by several billions of dollars. That's how much it costs to set up a new fab. We see a flowering of innovation in the ASIC segment of the semiconductor market, concurrent with an increase in patenting. We see a reduction in entry costs. The other thing, which sounds a little bit more technical, but this helps out the consumer, the supply chain starts to break apart. Instead of everything in-house, everything starts getting allocated to the firm that does it best. Why is the consumer helped out by that? Because you're allowing the market to discover the business structure that can deliver that product as cheaply as possible. That pushes down costs for consumers. Again, this is flipping the IP monopoly narrative on its head, because I just gave you an example where IP broke up an uncompetitive market, made it more competitive, arguably lowering prices for consumers, definitely increasing innovation.
So why is that view not taken hold? I mean, I think if we look at the IP and antitrust policies, going back to the 1995 DOJ guidelines on licensing IP, the subsequent business review letters from the late 90s until the IEEE letter in 2014 or 2015, they have all taken a conventional view of IP and antitrust policy. So why has your your
Yeah.
view, just not,
Yeah.
why is the unconventional view not taking
Yeah.
broader adoption?
Yeah. So let me give a little bit of context for the audience here, and I want to give some credit to the U.S. antitrust agencies. If you go back to the 1995 antitrust licensing guidelines, actually reaffirmed by the agency in 2017, that is brilliant antitrust policy there. It specifically says that IP rights should generally be treated just like any property right, and we're going to apply rule of reason style analysis to the whole panoply of licensing and IP-dependent business transactions. The mystery is, why has that not really penetrated the judiciary and the policy space? Okay? And now I'm gonna take this opportunity to talk a little bit about my book. The big steal and the suffix is ideology, interest, and the undoing of intellectual property. Ideology and interest, that's the answer to the question. Okay? IP equals monopoly is an assumption. It's a narrative that verges on an ideology in much of the policy space. Why do I call it it verges on an ideology? Because it is not sensitive in many cases to cost-benefit analysis or objections based on cost-benefit analysis. This has captured the discussion of IP rights, both in the antitrust space and the IP-specific spaces. And the question is, why is that narrative coming from much, not all, much of academia? Why has the policy space been so receptive to it? And the answer is what I call an accidental alliance in the book between ideologically motivated policy analysis, which tends to be unsympathetic to IP rights based on the monopoly assumption, and a significant portion, not all, a significant portion of the tech community that relies on a business model, what I call the giveaway business model, or vertically integrated business model, that thrives under weaker IP rights. As I document in the book, by looking at data on amicus briefs, lobbying expenditures, funding and sponsorship of advocacy organizations. Some of the largest technology companies, platform-based technology companies in this country have for decades pushed the message that IP rights are a monopoly, they are a tax, and this has produced tangible policy outcomes in Congress through the American Invents Act and through a sequence of decisions by the US Supreme Court and the lower court judiciary that is inimical to patent rights. This has favored one business model. It's a business model that has favorable effects in many circumstances due to scale economies and other reasons. However, it has an important social price. It suppresses entry. It raises entry costs for innovators and entrepreneurs who rely on different types of business models. And that's not good for the ecosystem in the long term.
Well, so I want to, since this is FedSoc, we have to debate everything. So,
yeah.
I do a lot of work with emerging tech, and, perhaps nothing is bigger than artificial intelligence. And you don't have a lot of patents in the AI space. A lot of the training data is open source, so it seems like we've had innovation and competition in those areas, even without IP rights facilitating tech transfer. So what is your response to that?
Sure. My fundamental point on the relationship between IP rights and competition markets is that, and this will sound technical, but I'll give you some tangible examples. IP rights are ultimately essential to enabling transactional freedom in innovation markets. It enables markets to choose from the full breadth of possible transactional choices. Is the fabless model in semiconductors the best model, always the most efficient model? No. But is the vertically integrated model sometimes better? Maybe, right? But we don't know. We don't want to put ourselves in the position of a government planner saying that the fabless model is always the right model, or the vertically integrated model is the right model. What we want to happen, we want to see the market competing on different models, right? When you have an IP right, you have an option to seek that right. Even if you have the right, you have the option to waive the right, to modulate it. That's what we're seeing right now in the AI market, right? OpenAI, notwithstanding the name, is mostly based on a closed tech model, right? Where we have Meta coming into the market a relative latecomer to the market. It's moving so fast. They're coming in with an open model. We're going to allow the market to choose. We see this over and over in tech history. Go back to the very beginning of the PC market. You had Apple, the pioneer, coming in with a closed model. Microsoft comes in with Windows. Are they totally open? No, but they're partially open. They revealed the application programming interfaces to the developers. The developers then produce far more applications for MS Windows and Apple. Microsoft wins that race. That's what we want to happen. Just like we want firms to compete on price, we never set price. We don't want to set the business model. When you pull IP rights out of the market, you only allow certain types of business models. You favor vertically integrated corporations. You favor systems integrated, platform-based corporations.
So when you wrote the paper we're talking about, how did you come to these findings? What interested you in this area? Tell us about what led to you coming to these conclusions. What was some of the research you thought about, some of the issues you thought about when you prepared this paper?
Yeah. This book, The Big Steal, that paper, a book that I published about 4 years ago called Innovators, Firms, and Markets. What I've been trying to do with these pieces is to take almost 20 years of research into the relationship between IP rights and business models in innovation markets, covering over a century's worth of US tech history. And I'm trying to distill this into policy lessons to have a favorable impact on IP policy and IP-related antitrust policy. I'll give you a personal story to explain how I came to this work. Over a decade ago, I decided to do a piece on a variant of the IP monopoly assumption, which is known as patent thickets. Right? There's a thesis out there, it's mostly theoretical, which says that when you have a market that has lots of IP rights and lots of owners, there's going to be fighting all the time, litigation and licensing, the whole market will collapse. So I decided to test out this theory by looking at a market that hadn't been researched. Scholars always want to find new stuff, right? So I decided to look at something that may seem a little technical, consumer electronics. That looked like a market where there's got to be a patent thicket because it's got intensive patenting and lots of holders all over the world. As soon as I started looking at this market, what do I find? It's hard to find a market that's more efficient. It's constantly innovating, and adjusted for quality, the prices per computing power, they keep decreasing all the time. And so the question then became, why is this market thriving in spite of having so many patents? And then you discover an answer that some of the specialists in the room may already know. You have standard setting organizations to ensure interoperability, and you have patent pools to push down the transaction costs, but at the same time, get royalties back up to the innovators to remunerate them and keep their incentives going to keep that innovation going. And that perfectly explains why you see a market that's got intensive patenting, it's got intensive innovation, and it's got constantly declining prices adjusted for quality. But I took that example one step further, and I apply it across virtually all IT markets and the life sciences markets. The question then becomes not why are these markets thriving despite patents, but why are these markets thriving because of patents, right? That's so quickly, it's something I just mentioned. The standard setting organizations in the IT space, we take it for granted, right, that your Galaxy phone can speak to your Apple phone. But this is the result of investment by companies in establishing standards through cooperative activity. And guess what? Information is being revealed in those organizations to competitors. It's the patent, it's the panoply of other IP rights, contracts, trade secret. Again, it's making that happen. That's a transaction enabler. That's even bigger than that because it's making an entire market. And again, it's lowering the entry costs because everyone can come into that market as long as they comply with the standard.
Yeah. Well, can you talk about patent holdup and patent holdout? Are they problems? Are they myths? Or are they what's your view on those issues?
Sure. So these phrases, patent holdup, patent holdout, they relate to a longstanding policy debate revolving around standard essential patents in the mobile communications device market, a market where it's difficult to underestimate the importance economically, difficult to underestimate the importance from a national security, global competitiveness perspective. The standard essential patent debate, the theory of patent holdup is one of the best examples that I can give you of what I had mentioned as this confluence, this accidental alliance between ideological approaches to antitrust and IP policy and business interests who align with those approaches. Right? So starting in the mid-2000s, antitrust regulators in the US, and then later regulators in the EU, and regulators in China and in other countries have subscribed to a theory, with the exception of 2017 to 2019 under the leadership of Macon Delrahim at DOJ Antitrust. They have largely subscribed to the theory of patent holdup. Patent holdup says that the standard essential patent owner, because they know that the implementers, the device producers, rely on that technology, they will demand exorbitant royalties capturing most of the value in the supply chain. This theory relies on principally theoretical articles in the academic literature. Those articles have been subjected to rigorous empirical scrutiny. Unlike the theoretical articles, the empirical studies, which were principally led by the late researcher Alex Galetovich, found, and other researchers find using different methodologies, that royalty rates earned by SEP owners in the smartphone market have typically been at modest levels. They've typically been at constant levels. That's not consistent with patent holdup. Patent holdup, we should see those rates increasing as the implementer gets more and more locked into the standard. Yet we do not see that. We have seen the position of patent holdup being advocated by device implementers, which is perfectly rational. They want to reduce their royalty rates, get it down as low as possible. It's an input cost, and every other business wants to do that. A 2015 Business Review letter issued by the antitrust agencies, similar positions taken by competition regulators outside the US, on the basis of patent holdup theory, have advocated for positions that make it hard to enforce standard essential patents, including, most notably, the near inability to secure injunctions. In this country, it's virtually impossible. But how does that change the incentives on the other side? Right? Even if you thought that patent holdup sometimes happens, even if you didn't think it happens systematically. But now you have taken away any incentive of the device implementer who has abundant resources to litigate almost indefinitely. They have no incentive to take a license. In an interview published in The Economist magazine, the former head of licensing at Apple stated precisely that. In a no-injunction environment, it is not consistent with business rationality. He even stated it would be inconsistent with fiduciary duty to maximize shareholder value to take a license. The rational strategy becomes to use and then induce a litigation from the innovator. Look at how much inefficiency is created here. The argument I've been making is that IP enables transactions. It would therefore follow that when you weaken IP, you disable transactions. You don't make it happen. What we've done in the SEP licensing market, regulators in this country, again, for the exception of 2017-19 under DOJ Antitrust, regulators outside the US, we have tilted the playing field. We have shifted bargaining leverage from a small number of companies that stand at the apex of the wireless supply chain. They're fueling the supply chain. They're innovating. We have shifted bargaining leverage. We have shifted value over to device implementers. They capture the bulk of the value in the supply chain. I have no view over who should get the value, how much you should get value in the supply chain. We just need an even marketplace to make that happen. Property rights make that happen in physical goods markets. It's the same thing in virtual goods markets. And that is why, for the most part, there's really no tension or contradiction between IP rights and antitrust, because they're both about enabling competitive markets IP is about providing the property right infrastructure that is necessary for those markets to function.
Right. I do want to come back to some of the things you said about patent hold up and hold out, but before we go there, I want to ask you a technical question about your paper. And you argue that patents enable transactions between innovators and the holders of complementary non-innovation assets. What is a complementary non-innovation asset? That's a term I never heard before reading this paper.
That's definitely, let's translate that into plain English. And I'll go back to my biotech example since you're already familiar with that one, right? We've got our scientist-founded startup. We've got a great idea. Okay? We want to translate that into a product, either because my investors want to make money, fair enough. I want to make money, and I want to help society. And that's only going to happen once I have an FDA-approved product on the shelf. Now, I'll go back to the example I'd mentioned. I was referring to the Cohen-Boyer gene splicing patents, the foundation of the biotech industry. USPTO was a pioneer here. They resisted calls in much of the policy debate. The US, one of the first country, to my knowledge, to extend patent protection to a biotech innovation. One of the members of the team then seeks VC capital, takes a license from Stanford University. They're the first named assignee. Founds a firm you probably heard of by now called Genentech. Genentech then, in the early 80s, releases the first FDA-approved biotech invention translated into a product that's synthetic human insulin. This is an absolutely wonderful thing for patients who depend on that. They've reduced the cost of that product by using gene splicing technology. The patent enables that by taking the idea. And what do I mean by these complementary assets? Well, one, I need money. That's a complementary asset. Two, I need expertise to produce that. An individual scientist doesn't know how to do that. Stanford doesn't have a production plant. But maybe Eli Lilly does. That's the partner on Genentech. Right? And it's that combination, production, distribution, testing expertise, all this has to happen. Goes back to my original point. The patents enable that to happen. They enable it at 2 points. One we're familiar with. One is when that product hits the shelf, it may be easily imitated. That's your exclusionary function. We need that function, right? But it's playing an enabling function in the behind-the-scenes stuff, in the plumbing behind the synthetic human insulin that allows that product to reach market. And keep in mind, average timeline on a successful pharmaceutical product, roughly a decade or more, right? There's a lot of transactions happening during that decade or more. We need IP rights, not just patents, trade secrets, contract, the whole bundle of IP rights to make that happen.
So it plays an enabling function, but you mentioned other things. You mentioned you need manufacturing expertise, which is innovative. That does not sound like a non-innovation asset. It takes distribution, which is innovative. There's a lot of other expertise that goes into bringing a drug to market, or for that matter, bringing a semiconductor to market. So while the patent may be, or the IP may be catalyzing the transaction, I mean, and this is the criticism I think you get to go back to the SEP example, the patent there is just one bit of the ecosystem. Now, maybe you argue that's without that, nothing else happens downstream, but how do you value the contribution of the patent to the innovation versus all the other things that happen in order to get a product to market?
Yeah, for sure. We often need, or very often need in many industries, we need the outside innovator. We need what I call the idea factories. Okay? This can be Edison back in Menlo Park, New Jersey. It can be Ray Dolby at Dolby Labs. These are your independent, your standalone innovators. For any Top Gun fans out there, I like to call these individuals the maverick innovators. They don't tweak the paradigm. They disrupt the paradigm. They're essential. We want an incentive structure that enables them to get the VC funding. We want to also enable them to enter into transactions with these other non-innovators in the supply chain. But we need IP rights to make that happen. It depends on the industry. Sometimes it's not going to be patents. Sometimes it's going to be copyright that's protecting their code. And I'd also like to point out something that is sometimes overlooked. that many times the producers are also themselves innovating. So if you look at patenting leaders in the semiconductor space, I'm going to tell you right now that one of the leaders you're going to find there, TSMC. TSMC has a rich patent portfolio, and why is that? They are innovating on the production side as well. So that's yet another example where we have IP rights enabling innovation, making the supply chain both more innovative and more efficient, and again, more inclusionary. We're getting more stakeholders in the system. We're not just operating within a walled garden silo.
Yeah. Your paper talks about 3 historical events in the IP world. One was the passage of the Bayh-Dole Act in 1980. One was the Supreme Court's Diamond v. Chakrabarti decision in 1980 as, I think, the last of its trilogy of patent eligibility cases from that era. And the third is the creation of the Federal Circuit in 1982 as ushering in an era of innovation. Can you explain why those were seminal events? And then talk about, has the rollback under Alice, under eBay, margin rights, has that had an impact on innovation, or has it, were those positive events?
Yeah, so let me take you back in time a little bit here. A book I published a few years ago, which I believe I referenced, Innovators, Firms, and Markets. That's an economic history of the US tech and patent system covering basically the entire 20th century. And we sometimes forget today, I sense in some of the debates, especially surrounding Bayh-Dole, the context in which that was enacted. That was enacted on a principally bipartisan basis. And what were policymakers on both sides of the aisle recognizing? They were recognizing what was called at the time the innovation malaise. Patenting had plunged during the 70s, and there was a general sense that the US tech economy had become less innovative. There was also a recognition that there were innovations being developed based on federal funding that were sitting on the shelf. I can tell you, I've done the hard, boring work. I've looked at these agency reports from the 60s and 70s, and they continuously say how difficult it is to incentivize private industry to take licenses at a zero royalty, but on a non-exclusive basis, to federally funded research. Bayh-Dole inverted that, they corrected that disincentive structure by enabling the market to take property rights and federally funded research. Chakrabarti, in a 5-4 decision, takes an expansive understanding of patent eligibility. I would also throw in there USPTO being one of the first to issue that biotech patent to Bayh-Dole. Industry looks for signals, right? Capital doesn't have to invest in innovation. They don't have to invest in biotech. When you supply a secure property rights infrastructure, now you've created a positive investment horizon for capital to invest. And those events that you mentioned, they were followed in short order in the 80s by an influx of venture capital into the biotech industry. That's the fuel you need to get the car going. That wouldn't have happened without the property rights infrastructure in place. The discussions that you see going on to roll back the Bayh-Dole Act, the revival of the taxpayer pays twice argument, I can take you back to 50s, 60s, 70s. People were saying the same thing then, and they got no private investment. All these things are threatening to roll us backwards. Out of all of the policy actions that we have taken roughly since the mid-2000s in this country on the IP system, if I had to pick one that I think has done the most significant harm, it's the eBay decision, but more specifically, the lower court's understanding of that decision, which takes the Kennedy concurrence and treats it as the majority. The majority doesn't say to treat certain entities differently, to treat certain inventions differently. And when you do that, right, if you don't have an injunction even after you defend the patent and show infringement, this is a very difficult and costly exercise. You don't have a property rights system anymore. You're starting to get into a compulsory licensing system. You're starting to get a system that favors infringers with cash resources to finance litigation indefinitely. And what I show in the Big Steel book is that this is sort of like a reverse Robin Hood effect, where we are shifting wealth away from innovators who are often smaller and favoring platform-based companies who perfectly rationally would like to procure outside innovation at the lowest cost possible. That may make sense in certain cases in the short term. It's almost certainly going to be a bad deal for the US innovation ecosystem in the mid to long term.
Well, so how is that a bad deal? I mean, what's going to happen? You'll either, if you're one of these companies, you'll either license the patent ex ante, you'll take the patent before or when you launch the product, or if you don't take a license, you'll get sued for patent infringement. You'll either settle the case, or you'll litigate to final judgment. You'll either have to pay a damages award, or you'll invalidate the patent or have a finding of non-infringement. So what is that? I mean, how is that view wrong?
Yeah, great question, because you hear that a lot. And I think my sense is much of the federal judiciary subscribes to the view you can make the patent owner whole through money damages. And there's a couple reasons why that is wrong. Okay? One is courts are inevitably going to get it wrong. They're never going to be as good as the market in ascertaining damages. Two is the time value of money, right? You're requiring a patent owner to sit through years of litigation today because of the PTAB, at least 2 venues in which they have to defend their patent. The patent is an obsoleting asset. It's constantly losing value. In any litigation where the infringer has greater cash resources to fund litigation than the innovator, than the patent owner, you're going to start to induce settlements that reflect that imbalance. You're going to start to induce settlements that do not reflect the intrinsic value of the innovation, but rather reflect the differences in bargaining leverage and cash resources between the 2 parties. And the last effect, which I think is overlooked, is that even in transactions where there is no litigation, you've now distorted prices of patent-protected IP assets across the board. Why is that? Because every single litigation over any asset, whether it's IP or a physical good, takes place in the shadow of litigation, in the shadow of an injunction, right? If you suddenly are not able to evict squatters from your home is worth less. That's what's happened to patent-protected assets in this country. And those are your immediate effects, but I can talk about broader effects in the economy as well.
Yeah, go ahead. So talk about.
Sure. I talked earlier about capital rationally is going to search for the highest return. And it's rationally going to stay away from sectors where the property right structure is insecure. Now, if it's the case, as is widely agreed, that patents and other IP rights are essential to investment in life sciences, if it's also, as it's widely agreed, that patents and other IP rights are essential to investment in medical devices, if they are similarly essential to certain segments in the semiconductor industry, what we will do is we may still see a lot of innovation in our economy, but the capital allocation has been distorted. It's going to move away from IP-dependent sectors and move towards those that don't. Now, why should we care about that? There's 2 reasons. One is we never want to distort the allocation of capital in the private market. We want the market to search for the highest return because, again, we don't want to be government planners. We're going to get it wrong 99% of the time. Markets don't get it wrong over the medium to long term because you go bankrupt if you get it wrong, right? The second reason goes beyond economics. Think about the sectors I just mentioned: life sciences, semiconductors, and certain segments of the hardware industry. All of these are not only economically significant, they're national security significant. Right? And so we're distorting the allocation of capital in a way that's not good in terms of economics, and it's not good in terms of national security, global competitiveness.
Great. I know we're coming up on the quarter of the hour, so if people want to start getting in line, if any questions, please do so. We have a microphone there, but the room, I think, is also small enough that you can ask a question for your table if you prefer. But I have just a couple more questions for you. So I want to ask one thing about the injunctions piece.
Yeah.
And you said that there's a notion that monetary damages are sufficient to, or they may or may not be sufficient to compensate the holder of IP rights. Well, what is your response, though, to someone that says, well, if you pledged your patents to a patent pool, if you agreed to license on a FRAND obligation, well, how can you have irreparable harm? Because you have said, I am willing to license this patent. So what is the irreparable harm there? Now, I know that gets into whether eBay was rightly decided. I know some people disagree with that, but it seems like how do you show irreparable harm in this situation where if you have agreed as the patent holder you want to license your assets, how do you have an irreparable harm in that situation?
Yeah, as DOJ Antitrust under Macon Delrahim made clear in clarifying the understanding of the 2015 business review letter, when a SCP owner joins the standard setting organization and makes a certain commitment to that organization, they do not generally make a commitment to not seek an injunction. And it would be irrational for them to do so, and it would be harmful for the SCP licensing market if that were the case, and we already see why. And going back to my earlier example, the reason that we want injunctions to be available in certain circumstances to SCP owners is that if they're not available, the licensees who have abundant litigation resources, they will never license. They will bring every licensing transaction into court. You're now pricing out the asset in court instead of the marketplace. You're undermining you're undermining the relationship between property rights and well-functioning markets. Now, on the other hand, I want to make clear that you could imagine circumstances in which an SCP owner would engage in behavior that is consistent with the theoretical models of patent holdup. But unlike in the US, the EU courts in the EU, courts in the UK, they have come up with a far more attenuated, nuanced approach to both support a licensing market in SCPs by allowing injunctions to sometimes issue, but putting conditions on that, right? And so the condition that you see was innovated by an EU court back in 2015, I believe, in the Huawei ZTE decision, and that allows an SCP owner to seek an injunction when the licensee is acting as what is known as an unwilling licensee. So I think that would be a far more nuanced approach. We can do that in this country as well. The federal courts could do this right now, even under eBay, if they followed the majority opinion. Even if we reversed eBay, the courts in this country would still have many tools, all the tools that they have in civil litigation to deter bad behavior. We've just taken things to an extreme, and what it does, it induces litigation that's costly, and as I mentioned, it also distorts the pricing in the market outside, even when litigation is not taking place.
So it sounds like your hypothesis is, or your theory is, that litigation is inherently inefficient. It's certainly expensive. Does the prevalence of litigation funding change your analysis? If you're a patent holder, you can secure funding. Does that change the asymmetrical problem that you talk about in this book?
It may mitigate it. Yeah, the litigation funding may mitigate it. I think in some cases when you have infringers that have cash resources that are exceptionally abundant, I don't think it's corrected in that case. And even in cases where it's mitigated, in general, we want to drive transactions into the marketplace. We want to keep them out of the courtroom. The market knows how to price transactions. Courts are not especially well positioned to do that.
Yeah. Now, you made a few mentions to the new Madison approach to IP that was pioneered by Macon Delrahim's Antitrust Division from 2017 to 2021. I see a few folks in the room who enthusiastically supported those policies and probably want to see them codified. But what do you think Gail Slater's going to do?
Wish I had a crystal ball. That's hard to say. We do have in place, again, they've never been withdrawn. We have the 1995 IP licensing guidelines, reaffirmed 2017. We have a wonderful body of federal case law coming, you go all the way back to the 1977 Sylvania decision. The court says there explicitly, don't use antitrust law to favor one business model over another. We apply rule of reason, balancing analysis to all of these licensing transactions. We treat IP rights as equivalent to property rights. Yes, they can be used for anti-competitive purposes in certain circumstances, just like any property right can. The antitrust agencies already have at their disposal the tools to do this in a way that is not ideological. It's informed by evidence. The evidence that I've accumulated over almost a decade's worth of scholarship, I believe firmly shows IP is a predicate for transactional freedom. Transactional freedom is important in particular for the maverick innovator, the independent innovator. And that's good for the innovation system as a whole because a robust IP system, it serves all stakeholders in the system rather than only one certain type of stakeholder.
Great. Well, so with that, I want to thank you for your time today, and I hope we have some questions from the crowd. And you don't have to end your questions with a question mark. We can hear views too.
Hi, thank you for coming today. Ethan Yang from the Cato Institute. Hi. My question is, so I'm sure you remember that during the last administration, the FTC started challenging Orange Book listings, particularly under the theory that it's preventing the entry of generic drugs on the market and that these listings many of these listings were allegedly improper. I was wondering, what's your thoughts on that? Is that an example of perhaps, not necessarily the patent system, but the broader network of IP rights, maybe not being perfect and perhaps could use some loosening, or do you disagree with the FTC in saying this is more just like Lena Khan's agenda and whatnot?
Sure. I don't have a specific view on that particular policy issue. What I would point out is that in the life sciences space, there's two important considerations to keep in mind. One, it's the industry where empirical evidence is the strongest, that capital will not invest in this industry without secure patent protection. And that's simply because there's no other industry where the disparity between the cost of invention and commercialization, including testing, one, are so exceptionally large in absolute terms, exceeding by the lowest estimate $1 billion, including the cost of failed projects. The timeline of development is so long, over a decade. Yet the imitation costs are very low. And because we know this, right, it's one of the industries where we know this with the highest level of confidence, we should be very careful about any policy step that weakens patent protection. It is going to inherently be a disincentive for capital to invest in that industry. The other thing I would mention that is also special about the life sciences is that in all of IP areas, we have our incentive access trade-off, right? But we need to be sensitive to access concerns because of non-economic public health concerns in the life sciences space. And we've already done that to a great degree, right? The US has the most investment in pharmaceutical development, reflecting its robust patent system. We also have the highest percentage of prescriptions filled by generics, right? So we have a concerted effort, a calibrated effort to try and address those. Given the strength of the evidence for the necessity of patent protection to support investment in biotech, not that we should exclude them entirely by any means, but we should look carefully when we are looking at policy actions that are going to weaken existing patent protections.
Really quick. Any advice for the new administration what to do about jurisdictions that misuse competition enforcement, and the air quotes are on purpose, to basically take away intellectual property rights?
Sure. In the coming administration, I think one thing we saw in the past administration was a departure from a bipartisan, multi-decade commitment, especially at USTR, to promoting a robust baseline of IP protections throughout the global economy. This is something that's good for the entire global marketplace for the same reason that IP rights are good for the domestic US economy. They enable transactions to happen anywhere in the world where the most efficient firm can supply that particular input. And therefore, we should encourage jurisdictions that are departing from that baseline to appreciate more deeply the importance of IP rights, not just to the global economy, but to those domestic economies themselves. Let me give you an example to show why this is not just theoretical. I'm going to take you right back to that semiconductor example. I told you that patent protection, increased participation in the patent system had occurred concurrently with the entry of the fabless firms, the entry of the foundry firm, the breakup of the supply chain. If you look at where that's happening, much of it is happening outside the United States. This is a spread the wealth phenomenon. You're breaking up the vertically integrated firm, and you're spreading that wealth to firms wherever they're located throughout the world that can deliver that function as cheaply as possible. When you have transactional freedom, the market will go to wherever those firms are located. And I think a firm commitment, a return to by USTR and other agencies to endorsing the importance of a robust IP baseline through the TRIPS agreement, through trade agreements, is something that's good for the U.S. domestic economy. It's also something that's good for the U.S. for the global marketplace as well.
Yeah, thanks. I'm going to take you right back into pharma, which I think is the most prominent in the public debate now. On the one hand, we have 1,000 analysts who are sharpening their pencil trying to see whether Eli Lilly and Novo, how much value they can get out of the GLP-1s before the patent expires. And obviously, patent expiration is the overwhelming item of analysis with respect to these companies. On the other hand, as you alluded to, we have the legislation for Medicare really breaking the patent period, and there's always been some debate about the length of the patent period. So do you think, I don't know if you consider pharma really a well-functioning market given the Bigfoot of Medicare that's in it, but could you state specifically to what do you think of that policy of the Medicare negotiation on blockbuster drugs?
Yeah, you're right. Pharma is immensely complex. It's got a lot of levers. I'm just gonna focus on the innovation side of the story. And I don't want to exclude by any means that there could be ways to improve patent protection, to modify patent protection, to get that incentive access trade-off just right. I think a lot of effort has been put into that in the pharma space, at least since Hatch-Waxman, to try and get that right. Again, I think the presumption in pharma should be robust patent protection, given that we know there's a close connection between investment and the security of property rights in that sector. And as a result of that, that also encompasses indirect policy actions that indirectly impact the strength of patent protection by distorting or interfering or intervening in price negotiations between patent owners and the buyers of therapeutics that rely on those patents. I hope that answered your question.
Do we have time for maybe one or two more quick questions? I know we're coming up at the bottom of the hour.
Hello, my name is Duane. I wrote down my question here so I wouldn't butcher it. As a as a mid-level IP litigation associate, I'm sometimes disillusioned by the prohibitory costs of IP enforcement and litigation. So from the standpoint of someone who's in private practice, I've sort of gone on this quest of trying to figure out how can I innovate or be innovative in developing cost-effective means of enforcing IP. So what advice would you have for someone in private practice seeking to do this at the ground level?
Wow, that's a tough one. I don't know if I have great words of wisdom on that particular question. What I can say is I do feel that if injunctions were more widely available to IP owners, I anticipate that litigation would be shorter, litigation would be less frequent, and that seems paradoxical, right? But the reason that that would likely occur is that when you have a property rights system in place, you induce parties to settle, you induce parties to transact, you take away the incentive from the cash-advantaged infringer to move licensing into the courtroom precisely because the patent owner has that shutdown injunction threat. In increasingly large categories of IP owners, of patent owners, there is no such credible threat, and therefore our incentive structure is to drive IP transactions out of the market and into the court place. We want to do everything possible to reverse that.
Thank you so much. Yeah, you did mention that injunctions are important to SEP holders, but BIO, the Biotechnology Innovation Organization, and their Deputy General Counsel, Hans Huer, said that it is extremely difficult to get an injunction order, and they do end up going to international court. So doesn't this bifurcate that idea of injunctions being important to SEP holders? Because it does deter them a lot, you know, especially the pharmaceutical companies and the ones.
I'm sorry, can you maybe move the mic away? I couldn't quite capture all of your question.
I was just asking that, you know, Hans Huer, the Deputy General Counsel for BIO, he said it's extremely difficult to get an injunction order, and they do end up going to international court. So why is it so difficult to get an injunction order over here?
Yeah, that's one is specifically because of the eBay decision. But even in categories where the way the courts have interpreted eBay does not consistently capture those particular patent owners, and an injunction may ultimately be available. As the previous comment was alluding to, the cost and the length of patent litigation may have been referenced in that particular remark. But I will just jump on that comment to point out to the audience, if you're not aware, certain jurisdictions, especially in Europe, Germany in particular, for example, do grant injunctions on SEP owners. And so what we're seeing litigation move into those jurisdictions. And what that's happening is that we are essentially exporting the ability to set the terms of the debate, set the rules of the game in the SEP licensing marketplace to jurisdictions outside the US, notwithstanding the fact that it still remains the case that US companies are the leaders in the chip design space. And so that's another example of a disincentive effect, not on the capital investment side, but on the litigation side you get when you have a patent jurisprudence that has been developed that is so unsympathetic to the patent owners. You either get capital moving out of those sectors or you get litigation moving to other jurisdictions.
Great. Well, Professor, thank you for your time today. And Nate, if you have any closing comments.
Sure. Just wanted to say that this was very insightful, very enjoyable. We look forward to having you back, Jonathan. Thank you, Brian, for your help with the conversation. On behalf of the Federalist Society, thank you very much, and thank you all for coming.
Thank you.